Hi, Thomas Brinsko here, CEO and publisher of BIC Magazine and BICmagazine.com. I wanted to discuss a critical topic with you that has significant implications for the government's regulatory power. I'm talking about last week's Supreme Court decision to overturn the long-standing legal precedent known as Chevron or Chevron Deference. That ruling last week sparked a lot of conversation and debate, and I wanted to break down what it means, why it happened, and what the future might hold for regulation in the U.S. Now, Chevron deference originated from a 1984 Supreme Court case, Chevron versus the Natural Resources Defense Council. Now, the heart of the case said that federal agencies should be allowed to fill in details when the laws don't have them or they aren't crystal clear. This legal doctrine, I learned about it in law school a long time ago, mandated that the courts should defer to federal agency interpretations of ambiguous statutes passed by Congress. Essentially, under the Chevron doctrine, agencies responsible for enforcing the law had the authority to interpret a little bit and implement it as they saw fit. Now, that kind of makes sense because the people in Congress aren't experts in a lot of different of life's many endeavors that they have to govern. Take fishing, for example. The case last week that was a 6-3 decision by the Supreme Court was actually a lawsuit brought by fishermen in New Jersey and Rhode Island who challenged a fee requirement. In this case, there was a law that required the government to monitor the type and quantity of fish that were caught. In deciding on how they were going to monitor the catch, though, the National Marine Fisheries Services issued a rule saying that the herring fishermen had to pay $750 to pay the salary of an observer to be on the boat each time they took a trip. Now, they didn't make a lot of money anyway. $750 was a big deal for them, and an extra person on a small boat, one less worker, right? Now, the lower courts used the Chevron doctrine to uphold the fee and required the observer to be on the boat. But when it went to the Supreme Court 6-3 decided to not rely on the Chevron doctrine, and they said that the court, not the agency, could have the final say in interpreting legislative intent. In this case, the Supreme Court didn't feel like the legislative mandate to monitor a catch included putting a government employee on every boat at the fisherman's expense. Take this logic into our industrial world. The EPA was given authority by Congress years ago to regulate air pollutants, which is a worthy goal. But the EPA, somewhere along the line, decided that carbon dioxide, a regularly occurring gas, is a pollutant not because it pollutes the air directly, but because it contributes to global warming. Now, is warmth a pollutant too? Until now, the EPA, under the Chevron deference doctrine, was allowed to decide entirely how they were going to regulate it. Consider 3 very recent carbon dioxide climate-related rules issued in March, April, and May of this year under the administrative state of Joe Biden. Now, 3 rules, 3 laws, the number of words, over 1 million. And here are the rules. The SEC Climate Disclosure Rule, the EPA's Tailpipe Emission Rule, and the EPA Emissions from Power Plant Rule. These 3 rules are over 2,800 pages long and contain over 1 million words. Hat tip to my friend Robert Bryce for the stats on the grotesque length of these regulations. Those regulations, of course, were never voted on by Congress. Instead, they are very detailed interpretations and extensions of much broader law passed years ago by Congress. The agencies are essentially bending and even rewriting laws to confirm their own agendas. It's basically regulation by strangulation. And it shows just how bloated and disconnected the administrative state has become. The cost of compliance with these rules by our industry could put companies out of business just as fast as the herring fishermen might have been put out of business. Now, the ruling overturning Chevron last week does not affect past agency regulations and actions. However, it sets a new precedent for future regulations. We can expect a surge in litigation as corporations and other entities challenge new agency rules. In the long term, Congress is probably going to have to draft more explicit laws to guide the agencies. It marks a significant shift in the balance of power between the federal government and the judiciary, and will likely have very far-reaching consequences for how regulations are crafted and enforced in the United States. As this new legal landscape unfolds, we at BIC will keep you updated with the latest developments. If you're not already following us on LinkedIn and Twitter, please do. And until I see you next time, God bless.